All right. I might move on then to kind of, I guess, some strategies for late 2021 and for 2022. And I think that, look, the other thing, obviously, businesses have got to start looking at a mindset change from thinking about tomorrow to maybe planning 6 months now. And obviously, COVID disaster payments have all ended. So a lot of staff, while the COVID disaster payments were being paid, a lot of staff were happy to do reduced hours and things like that. So now that that money's gone, those people, we're already seeing this with clients, they're already saying, well, no, I'm not continuing on my reduced hours at this point. And the employer, frankly, has no right to really continue those arrangements if those arrangements were sort of mutual agreement on a temporary basis. The Job Saver program, as you all know, ends 30th of November. And there's obviously some challenges around that because you got to maintain your headcount and those sort of things. So we've got clients literally ready to pull the trigger on redundancies, December the 1st. But basically, most businesses will either fit into one of three categories in the next few months. It'll either be expansion, contraction, or consolidation. And we'll kind of go into some of the things that each business in those categories should think about in that time ahead. I'll move on then to, I guess, consolidation. And for the businesses that aren't looking at a lot of big change right now, these are some of the things that maybe you should think about. And look, these are probably things that everyone should be thinking about, probably more so if you've got more time to think about these things. These are things that you should certainly consider. So the Fair Work Amendment Bill in 2021 basically made a change to look at this issue of sexual harassment. So what it actually said is that sexual harassment can now be a valid reason for dismissal, even if it's a one-off incident. The other thing that the Fair Work Commission can now do if an individual applies is they can make an application to the Fair Work Commission to deal with a sexual harassment matter or make orders about a sexual harassment matter to stop a certain thing happening in the workplace. So what you may have heard of before is the anti-bullying orders that the Fair Work Commission can make. And let's say, for example, I'm being bullied at work by another person. As long as I'm still employed, I can make an application to the Fair Work Commission to try and get them to stop the bullying at work, and the Fair Work Commission can make a range of orders. If I've already left the employment, then that's not available to me, but the Fair Work Commission can make orders for people who are still employed, either on now workplace bullying or sexual harassment. And that could mean, to give you an example of orders they could make, it could mean moving someone to another location in the workplace or moving someone to another department. They can make orders that are that significant to impact upon these things. But probably the one takeout from this in particular, don't worry so much about those orders because they are quite rare. The one thing that is very important now in this space is having workplace policies and I would say providing training in this space, because what the new amendment bill requires is that you must take positive, you must, I think the word is positive obligation to prevent sexual harassment in the workplace. And a policy is one thing, and that goes part of the way there, but providing some sort of training is also quite important. And just very quickly, I'll talk about a client issue that we had recently. It was a non-for-profit organization. They had an employee, a female employee actually, who groped a male employee in the workplace. It occurred on a number of occasions, but there was a particular incident in early June that occurred. And it was really interesting because we came on board with this client just a few days before this happened. So it was just pot luck that this issue came up. We assisted the client with the process. So what happened was the individual made a number of crude comments, was groping this employee, grabbing him on the backside. And basically, as a result of this, she was suspended. She attended a meeting about her ongoing employment. She admitted all of the conduct. She admitted all of it. There was not even a contest on it. Now, the employer said it was considering termination. The employee actually resigned, but then still run an unfair dismissal against the business saying, well, it was clear I was going to be terminated, but the client didn't provide me with any instruction or training regarding sexual harassment. Literally, the argument she was making, and this might sound stupid to most of the people on the group, but she was just making the argument that, well, I didn't know that what I was doing was sexual harassment. And I know that's crazy, but that's the argument she was running. And this matter went all the way to hearing. We actually had a hearing on the 29th of last month, and it literally settled on the day of the hearing. So the organisation decided in the end that it didn't want to involve various others in giving evidence in the matter. It did make a payment to her. Obviously, I can't disclose what that was, but it really highlighted to me that weakness in that particular case was that they hadn't done the training. And look, we'd only been engaged for 3 days, so we hadn't been able to even encourage the client to implement the training we recommend to clients that we've created for clients to deal with that, because it was just so quick. It happened 3 days after the engagement. So that's a really interesting point. The other one that you may be familiar with is casual employment changes. So now, for large employers with more than 15 employees, if you have a casual that's been employed for more than 12 months, you must make an offer for that person to convert to permanent employment. It doesn't mean they have to, and it certainly doesn't mean that they have to convert at the same rate. And that's the main reason why most casuals won't convert, because they realize they're going from casual rates to permanent rates. But the obligation is to make an offer. Now, what constitutes an offer? We've come up with some sort of letter style templates where basically the employer says, look, you've reached 12 months casual employment. This is our offer to convert. If you want to convert, please discuss it with us. But if you do convert, be aware of these things, because permanent employment has different, obviously, conditions to casual employment. So that's important. For small employers of less than 15 employees, you don't have to offer or make a formal offer to those long-serving casuals, but they can request conversion. So there's a kind of an additional compliance obligation, if you like, on larger employers when compared to smaller ones. But all of them, it's the same notion that if the employee has 12 months service or more of casual employment, they can request, or they can basically seek conversion. Now, whether you accept, you can reject that conversion, but you've got to have very good business grounds for not doing it. The way that the Fair Work Commission looks at this, and the way that this change has been enacted, is that, well, if you've had a casual that's been working on a regular basis for over 12 months, well then, there's clearly ongoing work. So why can't that person be converted to at least part-time employment or full-time employment? So there's certainly that's another key thing that's come up in it's come up in 2021. Question on that? No? Look, the only two other things I would mention in consolidation is, look, a lot of you would probably be familiar with the annualized salary requirements that were outlined in the Modern Award last year. Again, that's something that applies to, I think it's 22 out of the 130 Modern Awards. So that's something that we're seeing a number of questions from clients about. So if that's something that if you've got employees on annual salaries and they are covered by one of those awards, then good to seek some advice on that, because that's an important one. Some awards now require also mandatory classification. So what that means is that if you have an employee who's employed under some of the awards, what those awards now require is that you nominate what classification level that person is upon their commencement of employment. And to give you an example of this, I think the Clerks actually award is one of them. I think the Manufacturing Award also has some requirements for mandatory classifications as well in it. So I don't have a list of all of the awards with me today, but that's another more relatively small point, but again, something that came up in 2020 that we found in particular on that front. So another key issue to look at. I've only got 3 slides. I think it's 3 slides left. So this is a little bit about workers' comp, and it just goes into sort of the range of different, this data is a little bit dated in that, we've only got the 2017, 2018, but it does give a good indication as to the trends. And the one I've highlighted in particular is the mental health conditions. That seems to be something that's significantly on the rise, and probably the data would be even more than this, I would say, in 2020 and 2021. But what we're seeing now is that the average mental health claim, in terms of time off work after that mental health claim is made, that the average mental health claim is running for approximately 21 weeks. So consider this. So a person who goes on stress leave, workers' comp stress leave, the average amount of time that they will be off work with that particular condition is 21 weeks. So it's pretty significant. That's almost 6 months. Effectively, it's from what you can see in this list here, it's actually the highest. So it's even higher than, injuries relating to nerves and spinal cord, circulatory system diseases, and all the other things that are in this list. So if there's one other takeout from this conversation today, is that mental health is so critically important. One thing we do for our clients is we've actually got built into our memberships access to an employee assistance program, which allows people to seek counselling as they need it. We find that's a good way of preventing people from going off to workers' comp, because obviously once you go off to workers' comp, then you're talking about claims and potentially about premiums as well being impacted, whereas EAP can be a really good way of managing those issues before they get to workers' comp. If people feel like they've got an outlet to deal with these issues, they can deal with them prior to it escalating to kind of crisis point. So that's another really interesting one.